Morning. My name is Sonia Roland, and it's my great pleasure to welcome all of you to the law school for the conference on the global regulation of nanotechnologies. Looks like Linda already introduced me as a troublemaker. But we're very fortunate to have with us speakers from literally just about every continent. And that was one of the goals for this conference. A lot of the debate and discussion on nanotechs has been very transatlantic focused and domestic focused, and we really try to expand it beyond that and really bring people from everywhere and from every constituency as well, which also accounts for the organization of the panels. Instead of going sort of product or type of regulation by type of regulation, we've tried to focus on the different constituencies that are involved in the nanotech debate. So I know there are also many in the audience who are coming from afar, and will have great contributions to make to this conversation. And thank you very much, really, everybody, for coming. Before we start, I would also like to thank the university and the law school for their support in organizing this event. This is bringing together members from not just the law school, but also the College of Business Administration, the College of Engineering, the School of Public Policy with its Nanotechnology and Society Research Group. So I know that's something our provost cares a great deal about, interdisciplinarity, and so hopefully we try to make it happen here, and I'm really looking forward to it. I'm also immensely grateful to the number of students who have helped me organize this conference. In particular, I owe a great debt of gratitude to Lee Sapir, right here. Stand up, Lee. Lee's a third-year graduating law student, so just graduating in a couple of weeks. And she's been working long and really hard over the past 6 months to put this event together. Really, it just wouldn't have happened without her dedication, her professionalism, and her hard work and enthusiasm. So really, thank you very, very much. All right, just a few housekeeping matters. We have, for the attorneys who need CLE credit, we have a CLE sign-up and certificates of attendance, and also the written materials for this conference in the back of the room down there. So if you can sign in and out of every panel, and then take a certificate of attendance and instructions that will tell you how to manage it in the different jurisdiction. If you're interested in a jurisdiction that I haven't listed, please do come and talk to me, and we'll see what we can do to get accreditation where you need it. I hope you enjoy the program. The last thing is that we, as you probably figured out from the microphones, we are recording the proceedings. So in the Q&A sessions, please state your name and affiliation so we can have this on record and know who's talking. And also, of course, I understand that if you need to make a disclaimer that you're speaking in your personal capacity rather than your official capacity, please feel free to mention that as well. And then the recordings will be posted on a permanent link so that everybody will be able to access the proceedings of this conference. And I've already had a number of emails from people who couldn't come, but who were asking about this. So hopefully that'll work out well. All right, so before I give a sort of quick overview of the conference themes and objectives, I'd like to give a quick primer on nanotech just to help establish a baseline of understanding for those in the room who are newcomers to the field. The scientists in the room probably want to close their ears at this point, and we'll be right back. So here we go. Nanotechs. Well, a nanometer is 1/1000th of a meter, so it's really small. The order of magnitude of the human DNA, or a cell, a membrane of a cell. And it's actually really hard to capture. So you need specialized equipment, very fancy microscope to even see things at the nanoscale. It's a really challenging technology. Aside from those physical order of magnitudes, though, there's no uniform legal definition of nanotechnologies, and the reason for that is that it's a very eclectic field. It describes a number of different types of technologies that can't be captured in a single legal definition. Of course, for all of us lawyers and regulators, that's a bit of a problem, because if you can't define it, how are you supposed to regulate it, right? So that's one of the many challenges, and that's one of the debates in the field, sort of how to define and how to map out that field. Okay. Just again, continuing on the Nanotech 101 here quickly. Just to give a couple of examples of forms and uses of nanotechnologies. Basically, we can sort of envision two big categories, particles and features or devices in the nanoscale. Now, particles can be suspended in the solutions. For example, in cancer treatment, right now there's some trials going on where gold nanoparticles in the saline solutions are injected through the body, and because of the nanosize of those particles, they can go through blood capillaries. And so they can reach the cancerous tumor in ways that traditional treatments, chemotherapy, isn't as good at doing. So that's kind of the hope for this type of treatment, and that's really possible because of that type of size that we're talking about here. But nanoparticles aren't always just floating about in a solution. Perhaps more often, they're actually affixed to a medium. And an example here is food wrappers. Nanotechs are pretty big in the food industries, in the food and drink industries. So for example, you can fix a film of nanosilver particles to a food wrapper, and nanosilver has antibacterial properties, and so that helps the product in the food wrapper to stay fresh longer, right, because it doesn't go moldy. So that's another way to work with nanoparticles. And of course, you can start to imagine the risks and the issues that arise are going to be very different, because we've got a food wrapper in our hands as opposed to a particle in a solution that might just sort of, if you dump it in a sink, who knows where it's going to go, right? Your food wrapper, you know where it's going to go. All right, nanotechs are also really important in the energy field and the whole green tech industry. That really is a growing, booming field. Nanotechs have been used on window coatings to improve insulation and solar panels to improve efficiency. There's a whole range of applications there that are really booming in the green tech field. All right, so I just wanted to distinguish this from the nano features or devices in the nanoscale. That's, for example, the smallest transistor in your computer chip or your cell phone chip is actually in the nanoscale. Another example is actually the picture on the conference program. I'm very proud to say, is actually a picture in the nanoscale. And what you see there is a picture of a stainless steel surface that was cut and polished using a focused ion beam. This is where the scientists come back in. Okay? So that's what you're seeing here. You're just seeing something very, very, very small. All right, so why are those nanoparticles different from the bulk form? Because again, the big question is going to be, well, just because it has a new name doesn't mean it necessarily calls for new regulation unless there's something different about it, something special that's not captured in our traditional world. So again, I'll scientifically very sketchy my explanations here, but basically nanoparticles have a much greater surface area to volume ratio. And what that means is that for a same volume, you see that blue oval here is the same size in both cases. The red blob here that fits in that blue oval has about the same volume. In this case here, the top one, the surface area, the exchange with the outside world is going to be that boundary. Well, in this case, you can see the boundary is going to be much bigger because it's going to include all those groups. And of course, what that means is that the nanoparticle will be much more reactive to its environment because there's so much more surface compared to the volume to interact with the environment. Okay, again, very simplistic, and nanoparticles don't necessarily look like my squiggle here, but that's just to sort of make it more visually accessible. All right, and then of course sometimes the chemical and physical properties of a product are different between its bulk form and its nanoform. So then, as I was mentioning, what is different about regulating nanotechnologies? Just because it's got a new name, doesn't mean we need to treat it differently in every case. But in some cases, they do raise new issues, new risks, and in many cases, misunderstood risks. And that's a critical feature that we're going to explore, and I think will be a running theme throughout the panels, the uncertainty and the lack of knowledge regarding the specific risks and the difference of nano products. The first panel will give a snapshot of the state of affairs in a range of countries regarding nanotech regulation, how those different countries grasp those new regulatory challenges. Now, this is only a snapshot because we do have only a couple of countries here, but I do want to mention Arizona State University has developed this resource, which you can access on this website right here, which tries to map out the nanotech regulation in different countries. So you have a map, and you can click on every country, and it'll show you what the nanotech regulations are. Gary Marchant from Arizona State University is in this room right back there, and so I'm sure you were involved with that project and probably would be able to tell a lot more about it during breaks or maybe during your presentation, but an invaluable resource, and I think still in the building process. That's right, yeah. Okay. All right, so regulating in the face of uncertainty is always a challenge, in particular because our legislative and regulatory processes tend to be geared towards reactionary rather than anticipatory rulemaking. And the pace of regulation is not always in sync with the needs of innovation and of the market. And of course, that's a particular problem for researchers and industries that are developing and commercializing these nano products. And that's what the second panel, called From Labs to Market, will focus on. Regulation and of the manufacturing and commercialization of nano products is often seen as a tension between, on the one hand, industries who just want to plow ahead, and on the other hand, consumer and worker safety. While I want to suggest that this dichotomy is simplistic and often inaccurate. In fact, from what I understand, industries often want a clear and predictable regulatory framework. They need it because they need internal safety procedures, they need internal safety working mechanisms. They need to ensure to get insurance coverage for their operations, which they can only get if they have some notion of how risky the activities are. They also need to assess their liability exposure. Without these key elements, you can't run a business. And so you can't bring those new products to the market. So really the interest in regulation is actually common. Now, finally, in addition to domestic-based regulatory governance processes, maybe there's also a need for international coordination and cooperation. Indeed, nanotechnologies are traded internationally. Many companies that operate in the field are multinationals. We'll hear from a representative from Coca-Cola, and that's a paradigmatic example, of course. The safety concerns are also shared across borders. So we'll have a panel on intergovernmental solutions that will explore a number of issues in this arena, looking at cooperation between government or even government agencies, also looking at the activity of international organizations and other international groups that include industry and nonprofits in trying to figure out best practices really on a global level to learn from each other and also to create international standards that might help those businesses that operate globally in a more seamless fashion. Now, another way to look at the development and commercialization of nanotechnologies is intellectual property. IP is a very important vehicle for technology development and commercialization internationally, and the growing number of nanotech products is no exception. So we'll have a dedicated panel there that will discuss a number of the issues that arise in this field, looking both at the specific IP protection and patentability issues of nanotechnologies, and also at the role of IP in creating standards. And I was just mentioning standards at the international level. That's a field that a lot of IP lawyers and companies that develop IP products are involved in. And here I'm thinking of standards that might be private, developed by industries, or proprietary in other ways. Finally, because regulation doesn't exist in a normative vacuum, we will consider some of the policy and ethical debates that frame the issue of nanotech regulation. Now, this is a topic that I'm sure will come up sort of in a cross-cutting way in a number of panels, but we'll have two dedicated events on this issue. The first one will be Christopher Bosso's keynote presentation this afternoon. He will present the findings of the edited volume he recently produced with others in the Nanotechnology and Society Research Group. The book is called Governing Uncertainty, Environmental Regulation in the Age of Nanotechnology, and it just came on the shelf in February, so just the state of the art there. And then on Saturday, to conclude the proceedings of this conference, we will have an interdisciplinary roundtable that will bring together scientists, ethicists, philosophers, and lawyers to explore the public and private interests that are at stake here in this debate and look at how that has an impact on policy for nanotech regulation. I hope you'll enjoy the program. Each panel will reserve time for questions and answers, and so I really look forward to a vibrant discussion. Thank you very much, and I'll now turn it over to the first panel on domestic regulation. It'll be moderated by Jackie Isais.
Good morning, everyone. The panel, let me introduce myself, and then I'm going to excuse the panelists from sitting where they are, where they can't see the slides. My name's Jackie Isaacs. I'm on the faculty here at Northeastern in mechanical and industrial engineering. My role is a number of different areas. I'm one of the associate directors of our Center for High Rate Nanomanufacturing, so I'm in the science and engineering realm. But I'm also participating as a member of the Nanotechnology and Society Research Group with political science and philosophy, and it's a really interdisciplinary effort. So I am bridging the gap between technology and policy. We have a great set of panelists today. I will not introduce each one right now. I'm going to spend the time to do it right before they speak. So we will have 4 speakers. Linda Bragan is on Skype, and she'll be talking first, and I will introduce her in a moment. But Diana Bowen from Australia, University of Melbourne, Mario Bibic of the Ministry of Science and Technology in Brazil, and Rick Reevestein, did I say it right? Yes. All right, is from the Massachusetts Office of Technical Assistance. So we will hear from all of them this morning in this panel on domestic regulation of nanotechnology. They will each speak for about 15 minutes, and I'll give a 2-minute warning, except for Linda. And we're going to hold all of our questions till the end of the session, and whatever time is remaining. I urge each of you, you each have a little notebook inside your pamphlet brochure. Please write down your questions so that we can capture that for the end discussion. And I will excuse our panelists from sitting here to enjoy a seat where they can see something in the first row. And let me now make a first introduction for Linda Bragan. As you can see from the slide, perhaps, she is a senior attorney and director of the nanotechnology program at the Environmental Law Institute. She's done significant work on and research convening on programs under several of the major federal environmental laws in the U.S., including the Comprehensive Environmental Response, Compensation, and Liability Act, Superfund, the Clean Water Act, the Toxic Substances Control Act. So without further ado, you can read her bio at more length, but I'll give Linda the time to talk. Thanks, Linda.
Good morning. Am I on the video now?
Not yet. Hold on just a second, Linda.
Okay, because I did turn it on.
I think it might be best to put your PowerPoint presentation up on the screen instead of actually your video, rather than trying to do both.
Oh, okay. So I'm not going to worry about video then?
I think that's probably best, at least during your
All right,
presentation.
that's fine. Well, that's really good because I just noticed that when I looked at my picture up on the Skype screen, there was a humongous pile of paper that I should have filed before. So that's great. Well, good morning from Nashville, and thank you very much for inviting me to participate. Is the audio level okay?
It's perfect.
Okay, great. Thanks. I really do appreciate everyone's patience with my participation via Skype rather than in person. I know it isn't ideal, and I certainly wish I could be there with you, especially given the week we've had here in Nashville. I don't know if you've been following all the news stories about the floods, but it's been pretty awful. And the irony is that a few months ago I was living in Boston. My family spent last fall there, and we have since returned to Nashville. And in any event, I'm certain the weather is much better for you today than when I left in December, when there was already a whole lot of snow on the ground. So if we could go ahead, David, and go to the first slide. And I'm going to pause just to make sure in case David needs to tell me that there's a problem. But this should be the overview.
Linda, do you want to be on the initial slide or the one that starts with overview of the presentation?
Overview of the presentation.
Okay, that's the slide.
So what I want to do today is talk about environmental health and safety regulation of nanomaterials in the United States. And I'm going to start with an overview of the various environmental, food, and cosmetics laws that can be used to regulate nanotechnologies, and then spend a little more time talking about TSCA, the Toxic Substances Control Act, because that is actually the only federal environmental law that's been used to regulate nanomaterials in the U.S., although in theory there are many others. And then I'm going to spend, at Sonia's request, a little bit of time comparing how TSCA works to regulate nanomaterials in comparison to REACH, one of the primary European laws that can be used to regulate nanomaterials. So this is a lot to cover in 15 minutes, so the comparative discussion is going to have to be very brief. But before I start on the substance, I just want to tell you a little bit about ELI and our nanotech program. So David, if you could go to the next slide. We started our nanotech initiative in 2005 when it became clear to us that much work was needed to develop appropriate environmental health and safety governance approaches for nanotechnologies. And what I mean by governance is not just traditional federal regulatory programs under new or existing environmental statutes, which is my focus today, but also approaches and tools such as corporate stewardship, tort liability, state and local legislation, voluntary standards, liability insurance, international measures, and developing the optimal mix of these tools clearly is a significant aspect of the governance challenge. The work we've done on nanotech over the last 5 years is typical of ELI's work generally. We are a nonprofit research and education center. We don't litigate or lobby unless it is specifically to impart information about our research. We focus primarily on legal and policy analysis, but we also do convenings. We bring people together to discuss environmental law and policy challenges, such as those associated with nanotechnologies. And I would say the central theme of our nanotech work has been to determine whether and how various U.S. environmental health and safety laws could work to regulate nanomaterials. For example, are statutory amendments needed? Are new laws or regulations needed? And what are the weaknesses and strengths of applying the current regime to nanomaterials? If you could go to the next slide, David. This is just a list of some of the publications we've done. Many we have researched and written with partners such as the London School of Economics or the Wilson Center. And I also want to note that Diana Bowman was kind enough to invite us to write a chapter for an upcoming book she is writing and editing, in which we look at the media-specific environmental laws, Clean Water Act, Clean Air Act, and others, to determine whether they can be used effectively to regulate nanomaterials. So with this as background, let's turn now to the next slide, please, which is a list of the various environmental laws that could be used to regulate nanomaterials. And I emphasize the word could because only one law, as I said, actually has been used as far as we know specifically to regulate nanomaterials in the United States. As you can tell, there are numerous environmental health and safety statutes that in theory could regulate nanomaterials. Chemical laws are the most logical candidates, TSCA and FIFRA, because they're designed to address the risk posed by chemicals, particularly prior to manufacture and distribution. And I'm going to focus on TSCA today, not FIFRA, mainly because FIFRA only applies to pesticides, so its application to nano is more limited. But before we talk about the other environmental laws that the Environmental Protection Agency and the states administer, I also want to mention that another obvious vehicle for addressing the environmental health and safety aspects of nanomaterials is the Federal Food, Drug, and Cosmetic Act, which could, of course, be used to regulate nanomaterials in food, drugs, and cosmetics. And we have forayed outside our area of expertise, which is environmental law, to examine the food and cosmetic laws in a fair amount of detail in our most recent report with the London School of Economics. But as many of you know, food and drug law is a separate area of law, and I certainly don't purport to be an expert in this area. But in any event, to date, the Food and Drug Administration has indicated that it will not regulate food and cosmetics with nanomaterials separately as a category, but instead will regulate nanomaterials on a case-by-case basis similar to conventional materials. And it also still has not issued, as promised, any specific policies on nanoregulation. Now, as you can see, there are also media-specific environmental laws that, in theory, could be used to address risks posed by nanomaterials. And these include the Clean Air Act, the Clean Water Act, the Safe Drinking Water Act. In addition, the Superfund Law, or CERCLA, and RCRA, the Resource Conservation and Recovery Act, could be used to address nano waste. Many of these federal programs are delegated to the states to implement, so I'm particularly looking forward to hearing Rick talk today about how state agencies can use environmental laws to address risks posed by nanomaterials. And there are also what I would call pollution prevention laws, such as the Emergency Planning and Community Right to Know Act, which includes the Toxics Release Inventory. And these laws could be used in theory to require the reporting and disclosure of certain releases of nanomaterials into the environment. Now, before we turn to look at the primary U.S. chemical law, TSCA, in more depth, I just want to take a minute to talk about why it is that environmental laws have not been used to regulate nanomaterials. So, David, if we could go to the next slide. Let me just pause. And is the audio on the slides working okay?
Everything's working fine, Linda.
Okay, great. Thanks. So let's look briefly at some of the challenges of using these media-specific laws. And let me start by saying I think the bottom line for most of the statutes that we've looked at, and this is obviously an oversimplification as we've written many pages on this topic, but for the most part, I think these laws can be used to regulate nanomaterials. Now, in some cases, amendments may be needed to the statutes or implementing regulations to take into account the scale of nanomaterials. For example, environmental laws often contain quantity-based thresholds, and if these thresholds are not met, the law does not apply or imposes reduced requirements. And these thresholds obviously may make sense in the context of conventional materials, as small amounts of pollutants often don't merit regulation. But in the context of nano, such mass-based exemptions may prevent regulation where it is appropriate. But I think the most serious impediment to using environmental laws is that we just don't have the data and information in many cases to make determinations that are necessary in order to use these laws. We're essentially lacking many of the building blocks of risk assessment which underlies most statutes. And so we need to fill a lot of gaps with respect to definition and characterization, metrology, and testing methods. And of course, we need more environmental health and safety studies. U.S. regulators simply need more data to effectively regulate using environmental laws. In most cases, determinations must be made by a regulator before a statute applies to a nanomaterial. So, for example, in order to use RCRA, the statute that requires the identification, tracking, and safe treatment and disposal of hazardous waste, regulators at EPA or in the delegated state would need to make a determination that a particular nano waste is in fact hazardous. But current test methods for determining toxicity just may not work for nanomaterials. And similarly, determinations must be made such as whether a nanomaterial constitutes a hazardous substance for the Superfund law to apply, or that a nanomaterial is a pollutant under the Clean Water Act. And again, in many cases, the information and data just aren't available to make these determinations. And we're also lacking, in many cases, the technology for adequately monitoring and detecting nanomaterials in the environment. So in sum, it's not so much that the laws themselves can't work, it's more that we don't have the information, technology, and data to use them. And it would take a significant resource investment to gather the data, develop the technology, train the staff, and make the regulatory changes needed to make them work. All right, if we could go to the next slide, please. With all these limitations in mind, many of which also apply to TSCA, I want to look more closely at the law that U.S. regulators are relying on at this critical juncture in the regulation of nanomaterials. Now, by way of background, TSCA was enacted in 1976 and has not been amended since that time. And I think it's fair to say that TSCA is viewed as one of the weakest of the U.S. environmental laws by most stakeholders. And that's not to say there haven't been supporters of the statute over the years, but I think the most apt description I've heard is from Terry Davies with the Wilson Center, and he calls TSCA a statute with dramatic strengths and dramatic weaknesses. And this is because while it covers a broad range of chemicals and provides far-reaching regulatory authorities to address unreasonable risk, it also imposes numerous substantive and procedural hurdles that have limited EPA's ability to use the tools provided in the statute. So after many decades, the momentum for legislative reform of the statute is growing. The Obama administration has issued principles for legislative reform, as have key environmental groups and the principal industry trade associations and even some state governments. There have been several congressional hearings on TSCA reform, and just last month the bill was finally introduced in the Senate and a discussion draft was released on the House side. So the legislative reform process is underway, but it's going to take over a year, I would estimate, and probably much longer than that, to actually enact changes to the law. So given this time frame, we need to still consider how TSCA currently works or doesn't work, as the case may be, and how it's being used to regulate nanomaterials. So if we could go to the next slide, please. The primary mechanism under TSCA for reviewing the health and environmental risk posed by chemicals, including nanomaterials, is the pre-manufacture notice and review process, which applies only to new chemicals and significant new uses of existing chemicals. And so before a new chemical is manufactured or imported, the company must submit a notice to EPA along with certain information. However, in most cases, only known information about the health and environmental effects of a chemical is required. So no new testing is automatically required as part of the notice process. And as a result, most notices do not, in fact, include any health and safety test data. After reviews of pre-manufacture notice, EPA may determine if restrictions are required. And in the vast majority of cases, EPA does not impose restrictions, but it does on occasion by, for example, placing restrictions on use and distribution. With respect to nano specifically, EPA reports that it has reviewed over 100 nanomaterials as part of the PMN process and has taken action to control and limit exposures, things such as requiring the use of personal protective equipment and in some cases requiring testing to generate health and environmental effects data. And we know about some of the restrictions imposed, but a lot of the details are protected as confidential business information. Transparency, in my view, is a serious problem under TSCA. About 90% of all pre-manufacture notices contain CBI assertions, and EPA rarely challenges these claims. And that's something that will certainly be addressed in any legislative reform effort. In addition to review of new chemicals, TSCA allows EPA to regulate significant new uses of existing chemicals. To do this, EPA must first issue a significant new use rule, or a SNR, based on certain statutory criteria. But a SNR does not impose regulatory restrictions. It just imposes the same notice requirements as are imposed in the PMN process for new chemicals. So no new studies are required typically. There are 2 SNRs currently in effect for specific nanomaterials. There are also proposed SNRs for multi-walled and single-walled carbon nanotubes. And perhaps most importantly, EPA has stated that it will propose a broad SNR by the end of the year, which would require companies that intend to manufacture new nanoscale materials based on chemical substances that are listed on the inventory of existing chemicals to provide the agency with a basic set of information. So we're going to be looking for that by the end of the year. If we could go to the next slide on exemptions, I want to just mention some of the exemptions to the TSCA pre-manufacture review process that could apply to nanomaterials because they raise further concerns about TSCA as a vehicle for regulating nanomaterials. There are numerous exemptions under TSCA. I'm just going to highlight a few that are particularly relevant for nano. The first is that TSCA has a low volume exemption. EPA has said informally it would not make any sense to apply a low volume exemption to nano, but it has not stated this publicly as far as I know. There's also what's called a low release, low exposure exemption, and EPA reported more than a year ago that it had allowed some new nanoscale materials to be manufactured under this exception, but only where they said exposures were tightly controlled. And finally, another relevant exemption is for research and development. And interestingly, this is self-executing. EPA approval is not required to rely on the research and development exemption. So a lot of nanomaterials are presumably not subject to TSCA as a result of this research and development exemption. Okay, if we could go to the last slide on TSCA. I've just talked about new chemicals. EPA is much more limited in its ability to impose restriction on existing chemicals that are not significant new uses. There are substantial requirements EPA must meet, and these are so difficult to meet that EPA has restricted so-called existing chemicals, those are not new, that are not new. They've restricted them using this authority only 5 times since the statute was enacted in 1976. So, you think about that 5 times, and there are tens and tens of thousands of chemicals out there. So therefore, the question of whether a particular nanomaterial is new or not is very important in terms of the tools regulators have available to address possible risk. And then quickly, EPA can also issue rules that require testing of nanomaterials, but this again requires EPA to make a multi-pronged showing of the need for a test rule. And so it's not procedurally easy for EPA to require testing of nanomaterials, but again, EPA has stated that it is going to issue a test rule for certain nanomaterials by the end of the year. Similarly, EPA has some additional authorities under TSCA that allow it to require the submission of certain information on chemicals. And again, it is indicated it is going to issue a proposed rule. Again, these are proposed, not final, proposed rules that will enable it to obtain data about certain nanomaterials by the end of the year. Again, though, this is a fairly limited tool in terms of the scope and extent of data that can be obtained. For example, EPA can't order new studies under the Section 8 authority. It can only request known or reasonably ascertainable information. So to sum up on TSCA, EPA's statutory authorities are very limited under TSCA. These problems, though, are not unique to nano. They're just substantial procedural and substantive hurdles to gathering data and imposing restrictions on new chemicals, and particularly on existing chemicals. Okay, so I know I'm about out of time, but Sonia had asked me to say a couple of words about comparing REACH and TSCA. So if we could go to the next slide. And just to start off with, it's really important to understand that the two systems cannot be viewed in isolation. The U.S. and EU regulatory schemes are not separate. They influence each other in many ways, and these are just a few examples on the slide. I'm not going to discuss all of them today, but just to take one, multinational companies that operate in both the U.S. and EU that are subject to both regulatory regimes may take similar approaches to the manufacture and distribution of chemicals regardless of regulatory differences. So, for example, if one system places restrictions on a chemical and the other does not, a company may still opt to adhere to the restrictions even in the country where that isn't required for reasons of consistency or economies of scale or public relations. Another example is data or reporting of information. The systems are interconnected. One example is that data related to the toxicity of a nanomaterial that is included in registration materials under REACH could trigger an obligation for a U.S. company to report that data under TSCA. If we could go to the next slide, which we don't need to leave up, it's just a flowchart of one aspect of REACH, and I used this in a prior presentation. I just wanted to include it to emphasize that what I'm telling you is a vast oversimplification of how REACH works compared to TSCA. But if we could go to the last slide now, which is the comparison of some of the key ways they differ, I think the key feature of REACH is that's very different from TSCA is the registration requirements or the registration process, because companies are required to submit data and information about the chemicals they want to manufacture or import, and this is sometimes referred to as the no data, no market principle. The types and extent of data required vary depending on the chemical. For example, more data are required for chemicals produced in large volumes or that are high toxicity. There are some serious questions in my mind about whether the REACH registration process will cover nanomaterials adequately. These are related to volumetric thresholds and the extended 11-year timeline for implementation. But the key point here is that if a chemical or nanomaterial is covered by REACH, companies are required to provide information automatically, regardless of whether information is already available or must be developed. In contrast, as I mentioned, under TSCA, manufacturers are only required to provide information to regulators automatically if it's a new chemical or significant new use, and the information that is required under TSCA is generally information that's reasonably ascertainable, not new information that has to be generated. Then really quickly in closing, looking at regulatory controls, one interesting aspect of REACH is that it requires through the registration process that manufacturers apply appropriate measures to control risk that they identify on their own in their chemical safety assessment. Now these are only required, assessments are only required for chemicals produced in quantities over 10 tons. So it's a little hard to tell what the practical effect will be of this requirement for nano, but it may be an important way that risks are addressed, and there is no comparable requirement under TSCA. And similarly, REACH has an authorization process under which regulators develop a list of substances of high concern that may be subject to authorization, which means that a manufacturer or an importer must apply for authorization for each use. And the manufacturers also have to analyze whether safer alternatives exist and must prepare a substitution plan. And the point here is that TSCA does not prioritize, at least the statute doesn't, prioritize chemicals in this way and does not require companies to perform a substitution analysis or develop a plan. And then finally, on the basis of substance evaluation, EU regulators can restrict the manufacture, use, and marketing of chemicals. But here, the EU regulators have to show a risk to human health or the environment. It's too early to tell how this will work in practice, but the REACH restriction process bears a lot more similarity to the TSCA authorities for restricting chemicals because both require regulators to examine chemicals case by case to determine whether controls are needed. However, EU regulators are going to have more information and data at their disposal than U.S. regulators do under TSCA in making determinations about restrictions because of the registration requirements under REACH. So I will end there, and I'm sorry I went a little bit over. I really appreciate the opportunity to participate in the conference, and I'm really looking forward to listening to the other panelists' remarks. Thank you very much.
Thank you so much, Linda. We're going to move on to the next speaker, and I will introduce Diana Bowman, who is a senior research fellow in the Center for Health Policy Programs and Economics within the Melbourne School of Public Health at the University of Melbourne. She's also a visiting international scholar in the Department of International and European Law in the Faculty of Law at KU Leuven in Belgium. So I will let her set up her slides.
Good morning. Thank you very much for having me here. It's an absolute honour to be here this morning. I do apologise if I'm looking slightly jet-lagged. It's a 30-hour flight from Melbourne, and it's about midnight in Melbourne too. So I very much appreciate being put first on this morning because if we waited till the afternoon, I'm not sure how I'd be faring. So thank you very much for the organising committee for doing that. Just by way of background, I have been working in the area of regulating nanotechnologies for about 6 years now. My PhD, which was done in the law faculty, was actually on the issue of regulating nanotechnologies and was looking at this issue from a comparative background. So while I guess specialise in terms of the Australian regulatory framework, I've actually done quite a lot of work in terms of the European perspective as well. I don't have a group. I do this work now by myself at the University of Melbourne. So after hearing Linda, I feel a little underprepared in terms of the people I work with. Now, this is my brief this morning. I'm just going to briefly address how nanotechnologies are currently regulated in Australia, and I'll do that by reference to a report that I was involved in 2007, identifying where the gaps are at the moment in terms of the Australian regulatory framework, what's actually happening in terms of policy initiatives in Australia, and where does Australia appear to be heading in terms of our regulatory and policy agenda. Now, just to give you a bit of context, in terms of the Australian nanotech scene, and I would doubt that very few people would know anything about it. We have approximately 80 nanotech companies in Australia. 21 of the 41 universities are currently undertaking research and development activities of some kind. We have no data on how many people are actually working in the so-called nanotech field at the moment. And the issue of workforce and exposure in the workforce is a really huge priority at the moment in Australia, and I'll get to why in a couple of slides. I've also put up some of the funding figures of how much is being spent by the federal government in terms of looking at nanotechnology, in terms of health and safety, measurement, and also industry uptake, public engagement. When you look at these figures compared to what's happening in the EU under the Action Plan or the National Nanotechnology Initiative here, we're talking very small dollars. And usually if I was presenting this, say, 12 months ago, you could nearly half what the Australian dollar is, but thankfully the Australian dollar is actually looking a lot better against the greenback at the moment, so it's not quite as bad as what it used to look like. But what's really interesting is, despite the very small size of the nanotech scene in Australia and the very small monetary commitment by the federal government, Australia is one of the, I would say, leading jurisdictions in terms of policy development and regulatory review and action on that front. We also have some of the leading NGOs based in Australia agitating on this issue. So it is interesting, the comparative between low dollars and low involvement, really, but quite a lot of activity. Now, in 2007, the federal government initiated a regulatory review. They put it out for tender. It was an independent review, and the aim was to assess Australia's existing regulatory framework to determine if and under what conditions nanotechnology-based materials, products and applications and their manufacture, use and handling are covered by the existing regulatory frameworks. Now, the idea of the review was to take a whole-of-government approach. Unlike some of the other reviews which have been done in various jurisdictions, the aim was to actually look at the whole spectrum. So we looked at 10 federal agencies and 1 state agency. We looked at approximately 60 regulatory instruments in total. And this wasn't just limited to acts. We had to look at regulations, codes, and the legislative instruments that underpinned really that top point of the apex. We had 3 months to do the review. We had 14,000 pages of legislation to read, and that was between a team of 3 people. Unfortunately, only 2 of us had a law background, so that meant 14,000 pages between 2 people. Slightly, a small job. Now, this is, the landscape that we had to cover. So we didn't just look at medicines. We didn't look just at industrial chemicals. We looked at everything from veterinary and agricultural chemicals, import and export under the quarantine and also the customs framework. And if you start to think about it, given the very small size of the number of businesses and universities involved in nanotech in Australia at the moment, a lot of the nanotech products that we're going to be seeing will not be manufactured in Australia. They're going to be imported in. So the issue of import-export was really important in terms of the review. We had to look at the environment. Now, the environment is regulated on 2 levels in Australia. So you have federal overarching framework, but also state laws. So that is why we had to look at the state perspective in terms of the environment as well. We had to look at the movement of goods. So under the DOTAS framework, what happens when nanotechnology is in a tanker in terms of whether it's some sort of liquid or some other waste product, and see how are they regulated. We have food, gene technology, obviously industrial chemicals, therapeutic goods, and we also had to look at the intellectual property rights framework, all on the perspective of health and safety. Now, this is a very simplified version of what we found. The Australian government accepted the findings of the Monash report, and when we put our report together, which was 100 pages, and that was limited by the tender document, we had to come up with something that didn't actually have recommendations as well. So we were told that we were not to have the word recommendation in that report, so we kind of came up with conclusions or recommendations without doing so. And we tried to bring it down to just 6 areas. So the areas where potential gaps or triggers, as we reframe them, because we weren't supposed to use the word gap, despite, again, being able to identify what the gaps were, was looking at issues around the name trigger. And while this is obviously Australian-specific, our review, these type of triggers identified are common to other jurisdictions. So it came down to the issue of new versus existing, as Linda's already talked about under TSCA, the issue of mass or volume triggers, knowledge triggers. Do we even know something's at the nanoscale? Triggers reliant on conventional risk assessment protocols, the R&D exemption, which again Linda's already touched upon, and international documentation. So Australia's regulatory framework actually refers back to a lot of international standards and other conventions. So if we need to reframe how we regulate nanotechnologies in Australia, it's not going to be simply a matter of tweaking at our own legislation. There's bigger picture issues at play. As a result of our report, which we handed to the government in 2007, it was actually publicly released in 2008, so a year after we actually finished the review, and that was so that our report could go to all the regulatory agencies. They could actually start to prepare their responses and get some action happening. We're starting to see quite a lot of activity in-house, and we're starting to see some harder changes occurring as a result of this report. One of the things that we identified in the report was in 100 pages to review 14,000 pages of legislation, as well as 11 agencies, we couldn't cover everything. So we suggested to the regulatory agencies themselves that they really had to now take our report as a starting point and really drill down into their own regulatory frameworks, look at the nuances that we couldn't actually attack. And that's actually happening. So our therapeutic goods regulator, our industrial chemical regulator have all started doing their in-house reviews. So our report really is the template, the starting point for that. Issues around new and existing have formed key parts of those discussions. And our industrial chemical regulator issued a public consultation report in November, December last year, looking at how they can amend the industrial chemical regulatory framework in light of nanotechnologies. They have not suggested that we should consider all nanotechnologies new industrial chemicals for the purposes of regulation. They're really focusing on, in terms of, the existing ones that are already in play, really focusing on other areas that they can tweak the framework. So things like the R&D exemption is one area where the regulator may actually enact change to actually capture some of these new nanotechnologies. There's also discussion regarding the mass and volume triggers, and one of the points that Linda touched on is that we have low volume exemptions at the moment. One of the areas that our industrial chemical regulator is looking at changing is to actually lower that threshold for nanotechnology, so it would be down to 100 grams per year. So while the low volume exemption may still apply, it would be a lot lower to take into account the fact that with nanotechnologies you need a lot less. We also have, our regulatory agencies recognising they can't do this alone. So given that there are international documentations and our regulatory framework needs to be in line with what's happening internationally, our regulators are working with the regulatory agencies in Europe and here in in the US, in terms of trying to be consistent in the approach, especially around the issue of definition. At this point, we still have no definition in any of our legislative instruments, but it is something the industrial chemical regulator is looking at implementing, obviously, as part of any change. So that's 3 months of my life in one slide. Moving forward, Australia is very interesting in terms of what's happening on the NGO side. And I'll start with the Friends of the Earth Australia Nanotechnology Project, who have been very active in this area. One of the advantages for the NGOs in Australia is that with a population of 22 million and probably a population interested in nanotechnology of in the 100 to 200, it's very easy to make a name for yourself very quickly. Also, if you're going to any meetings, whether it's government or academic, generally you can walk into the room of 50 people and you'll know all 50 of them, and it will be a case of, oh, I saw you last week, how did you go? So it makes it very easy to make a profile very quickly, but also in terms of engaging with key stakeholders and the media. And the Friends of the Earth Australia project have done that very well. They're very vocal and organised and working with other NGOs to get their point across. They've been calling for moratoriums in specific areas for some time now. The issue of sunscreens is obviously a very important one in Australia given our high rates of cancer. And Friends of the Earth have really targeted sunscreens as one of the bases or platforms to actually springboard the nanotechnology issue off. So they have safe sunscreen guides that they send out. They have been, over the summer, in the newspaper continuously going on about the use of titanium oxide and zinc oxide in sunscreen. So they really are playing a very key card in getting their message across. They have also been key participants in discussions around the industrial chemical framework and really called again for the regulator to impose a moratorium on the commercial use of nanotechnologies until we have more data. Now, from the government's perspective, they've just said that's not going to be possible. But it is interesting that they keep going back to this and basing it on the precautionary principle, which the precautionary principle is enshrined in some of our environmental legislation, but that's about it. The Australian Council of Trade Unions is an interesting case study in NGO activism in Australia as well. The history of asbestos in Australia is still very large and in the media. Mesothelioma has killed many Australians over the years, and I guess we had one of the worst companies involved, James Hardie. So the unions have seen nanotechnology as potentially the next emerging technology that's going to have a huge impact on the workforce. And through 3 or 4 or 5 key people, they've really taken it on board, so much so that there's a huge conference in Canberra later on this month focusing on, obviously, occupational health and safety, and one of the main streams will be on nanotechnology. So when papers are published in Nature Nanotechnology that basically say that carbon nanotubes act like asbestos, you can imagine that our labour unions pick this up very quickly. So they've got a very sustained, visible pressure, and they're calling for legislation to be changed. Some of them are calling for more wholesale legislation changes, others more tweaking. So there is going to be continual pressure, and until the government acts accordingly, I can't see them going away quietly. Moving forward on the government side, we now have a national enabling technology strategy. So where we used to have a nanotechnology strategy, we've now gone to an enabling technology strategy. So the Australian government is starting to lump nanotechnologies and biotechnologies in together, and with ICT as well. So really moving away from just framing it as a nanotechnology debate. They want to guide the responsible development of nanotechnologies under this framework. And again, one of the advantages of Australia in doing this is that it's a lot easier to have a whole-of-government approach. We can very easily get our regulators from the key 10 or 11 agencies in one place at one time. As most of these regulatory frameworks are dealt with at the federal level, it's a lot easier to make changes than what you would have in the EU or the US as well. So a whole-government approach isn't unrealistic. It's just settling on what that approach is going to be. And we have many agencies with a watching brief, so especially on the import-export side. Those agencies don't feel that they are actually in the position to do anything wholesale at the moment or even tweak their existing frameworks. So they're taking a watching foresight approach. So the focus, and this is my perspective of what's happening in Australia, is really focusing on the implementation and effectiveness side of things at the moment. While we will start to see the tweaking and we will start to see some nano-specific legislation in the not-too-distant future, and the first being under the Industrial Chemical Framework, it will really be a matter of changing the underpinning guidance documents and those key strategy documents before we see more wholesale changes. That's it. Thank you very much.
Thank you. Our next speaker is Mario Bajbic, and he hails from Brazil. He's a scientist working in the Ministry of Science Technology of Brazil, and he's going to talk with us today about Brazilian regulation.
Good morning, everybody. Let me start by thanking the organizers for inviting me here. I'm going to deceive a little bit my audience by saying that I'm not going to speak very much about regulation in Brazil because there is none specific for nanotechnology. We do have general regulations that have to be respected, not as strict as REACH in the European Union. But anyway, it's something that any new material, any new substance has to pass all sorts of regulations. We don't have specifics, but we are working on it. In particular, we have a competitivity forum that was formed. One of the working groups is exactly on regulations, okay, which involves both the government, the industry, and the general public. Also, in part, I'll show you next, but in part what we have is we have favored the activities of InMetro, which is the equivalent of NIST, because of the problem of metrology, which is really very important for regulations. You have to measure things before you regulate about them. Okay, so I'm Mario Bajvic. I'm in charge of nanotechnology in the Ministry of Science and Technology. And, well, I'll pass through these very quickly to go to have an idea of what's funding in Brazil. Funding for research and development and innovation. Essentially, this is a projection, okay, made in 2008 for the years, what we had in investment in research and development. The total aimed at 1.5% for research and development in the country, which is much more than all our neighbors. This is just to show, how the total went from the public side and the private sector. We have more investment from the public side than from the private sector for research and development. So that gives the government a handle on what is being done. Okay, so if you look at what happened, this is the investment in nanotechnology. Till 2008, we were raising nicely. Till 2008, we had the problem with the crisis, and there you have it, reducing the amount of investment. This is in reais, which means nothing here. So I'll have it in U.S. dollars, which is basically the same. We had a very nice slope for that that we hope to regain this year. The same kind of increasing in funding. We have a scientific community dealing with nanoscience and nanotechnology with more than 1,400 researchers, and we have about 2,000 graduate students with federal government scholarship working in projects involving nanoscience and nanotechnology. These are, some centers in universities that work in nanoscience and nanotechnology. Don't bother reading all of that. It's just to show you that we have about 48 universities and centers that work on nanoscience and nanotechnology. These are companies with projects in nanoscience and nanotechnology, and this is a huge list that it's about 130. We don't have the survey is being done right now to get the real number of companies that are working there. In this, we involve both multinationals and small enterprises and all that. This is this graph shows the production in terms of papers published in nanoscience and nanotechnology in different countries in Latin America. And Brazil has the highest rate there because it's larger. And essentially, what you get is an increasing participation in the nanoscience. If you get the idea that in general, okay, for science in general, we publish about 2% of the total worldwide, okay, and that nanoscience and nanotechnology is more active in Brazil than the average, you would guess that you get, very good participation out of the infrastructure that we have. Okay, what we have is 12 thematic networks, 3 regional networks around some specific labs, and 15 what we call National Institutes of Science and Technology, which are networks as well, working in nanoscience and nanotechnology. And we established 6 national laboratories for nanoscience and nanotechnology. To give you an idea, well, the thematic networks range from nanophotonics to nanotoxicology, nanoscience for agribusiness, and you go from there, carbon nanotubes and microscopies and all sorts of things. If we have 3 regional networks centered in 3 different labs, those are the 15 national institutes dealing with also material science and nanobiopharmaceuticals and organic electronics and all sorts of different things. So these are the 6 national laboratories. This is the first one, Setene, is in Recife, which is in the northeast, and this is something I want to discuss a little bit with you. CVPF, which is in Rio, in Metro, which is the metrology laboratory we have in Brazil, which has a nanometrology laboratory to establish standards for nano. This is also in Rio. Embrapa, which deals with agribusiness in São Carlos, in the state of São Paulo. The National Synchrotron Lab, which has a center for nanoscience and nanotechnology in Campinas, which is also in the state of São Paulo. And then in the south, in the south of Brazil, which is one of the centers for one of the regional networks. To give you an idea, this is where we are in the south, which means it's a big country. You can see it here. You have all the labs pointed in the map, and the last one is the one in Recife, which is Setene, and this is basically, I want to point out the importance of this, because it's the first lab in a region which has a technology density much lower than the rest of the country. Okay, so the idea is that by law we have 30% of the funds that must go to the northeast, north, and center-west regions. To give you an idea, well, it's easy to translate there, but the largest part of the country gets about 30% by law to force money to go to these regions. We have been doing this sort of thing, that promoting this sort of rule since many years. Like, what was done 50 years ago with the change of the capital from Rio to Brasilia. Okay, the results are visible now after you have enough time to see the results. And similarly, the results for these regions that I mentioned are beginning to show. Because participation on the total is on the rise. But this is too early to have final numbers for the action. Okay? To give you an idea, Brazil is very strong in agri-food applications of nanotechnology, with nearly double the world participation than other subjects. I would add to that great work on cosmetics, drugs, nanobio in general, chemicals, and photonics. Well, we have other subjects, but with less specific weight in the world scene. Problem is our share of patents is much lower, and although this is rising rather steeply in the past few years, we do have troubles in this part, which is transforming nanoscience into nanotechnology. Just to give you an idea, some Brazilian products, I'll go just cosmetics and antibacterial things, and this is actually the Aquamare there on the right. It's a nightmare, legal nightmare. Essentially what it is purified water from the ocean. Okay? It retains 60-some minerals in it. It's drinkable water. It got through all the FDA regulations in the States, and it's sold here. We can't sell it in Brazil because the rules for drinkable water, you don't have it on the list of the possible sources. Okay, the law was passed in the 1930s, so ocean was not a source. Well, electronic tone, nose, things that are used in washing machines, and I just want to point out that while there is a world market in expansion, steep increase in funding. This is probably, you know this is from Scientifica in 2009. This is the global funding in 2004, okay? And essentially you get the European Union and the States leading. If you have it in 2009, what you see is that China starts and Russia appears very strongly. You still have the lead from the European Union. Well, this is misleading because what you have to do is correct for the purchasing power of the money you get. And by doing that, you realize that China and the United States are investing more or less the same. Russia is the largest individual investor. But what's important is that we are still not in the picture, okay? And the way of, one of the ways of being in the picture is having international collaboration with nanoscience and nanotechnology. So I have a long list of countries that we have or we will have. We are in the process of getting MOUs and to get collaborations. Through these collaborations and government actions in the industry, we intend to be on the map in the following years. And all this is to say thank you, obrigado.
Our final speaker for the session is Rick Reibstein, and hails from the Massachusetts Office of Technical Assistance. He's going to offer some perspectives from the state level and compare them with other regulatory levels.
and to advance it, just okay, thank you. I want to take advantage of the disclaimer option. I work for the state of Massachusetts. I cannot speak for the state of Massachusetts. To do that, I would have had to submit this talk to my superiors and have them give their approval, which I did not do because I'm working on many projects. And this is actually an issue, which is the resources available at the state level. I have to do this work in my very spare time. So that's an issue to talk about, which goes along with the capacity, the legal capacity under the existing statutes. And I also want to thank the organizers for inviting me. The state perspective is not always included in these sorts of discussions. The Commonwealth of Massachusetts began its focus in 2006, and we've had two conferences. The first one, by the way, was called The Big Picture, which is the focus we've been trying to get, which is we can always get lost in the details and split hairs, and with Nano you can split hairs indefinitely. And we want to keep the focus on the big picture, some simple ideas, simple, as my friend Marvin Lewiden says, but not simplistic, that can guide us through this labyrinth of details where you can easily get lost both technically and legally. Our focus was really begun by the Massachusetts Department of Environmental Protection. I want to specifically mention Carol Rowan West, who heads something called the Emerging Contaminants Committee. So DEP has had this committee to look at new issues for some time and decided to start looking at nano, and I may be actually having too late a date here. After working on these two conferences and having many internal meetings, this group created an interagency committee, which includes all of those different agencies, and I want you to specifically note economic development was included there. And I will talk more about the concept of safe development, which is what we think we've contributed to the discussion, is that term. And because that includes actually promoting the development of what you might call good nano or green nano that we want. We do have, as you can see, public health, occupational safety, environmental protection, and TURI stands for Toxics Use Reduction Institute. And I am from OTA, the Office of Technical Assistance, which used to be called the Office of Technical Assistance for Toxics Use Reduction, and is now not called that because we focus on energy efficiency and water and all waste, so it's all sustainability. But that is our grounding, and Massachusetts has a very strong law for toxics use reduction. So you see a very big focus on environmental and safety and health here, but our approach is safe development, that we don't want that to go so far that we hinder the development of new things that we want, and we don't believe that an extremely strong focus on safety will do that. So that's probably the most important thing I'm going to say today. We also formed an advisory group welcoming others to come in and talk with us about this. A few words about OTA. We actually are a new kind of agency. It's really 20 years old, but still it's a new idea. We're not a regulatory agency. We provide free and confidential assistance to businesses. We've done that to almost 2,000 entities over the past 20 years. It's misleading to say companies because many of them are institutions and households. And actually, counting institutions and individuals and households, we're well over 2,000. So they can tell us about their issues and ask for help and tell us about violations, and unless it's a threat to public health or someone, we keep that confidential, and that's provided in the toxics use reduction legislation. So that's a new idea in governance. And I applaud Linda Bregan for introducing that term, because often our focus is just on what regulations should we pass. There are many things that governments can do which are not restricted to regulations, and I think that's very important to note. And I've had a perspective for the past 20 years working in assistance that has convinced me of this repeatedly. There's so much that we have been able to accomplish simply by helping people. And before you run with this idea to say, well, then we don't need regulations, let me just make sure you don't do that. We need regulations, and because the regulations are there, and when they get stronger, the effectiveness of the assistance programs increases. What we need is what I call a two-handed approach. You lead with the friendly hand, and you're ready to smack with the other one if you have to. That's the big picture that I'm trying to put across. And we also, just to clarify, the toxics use reduction idea is one of going to the source of the problem, root cause analysis. A source reduction approach leads to the evolution of process and product design efficiencies. When you look at the actual root of the problem, then your scrutiny of environmental issues becomes a key to improving what you're making and the way you make it. So if you just look at things from the outside and restrict yourself to your environmental task and you don't actually look at the cause of the problem, you're not necessarily going to get to efficiencies. You're not going to necessarily prompt better development of technology. But if you go to the root cause, you can do that. Just want to mention OTA has issued an invitation to nano businesses in Massachusetts to join the Mega Nano Forum. I'm going to refer to my friend Seth Coe-Sullivan here. And we're trying to put this together. Mega Nano means Massachusetts Environmental Health and Safety, Green Alternatives. We have also created a Safe and Green Nano listserv, which has not been a raging success. Usually 80% of the posts are from me, so I'm hoping that more people will join that. And I want to thank the UMass Internano group for hosting that, putting that together for us. And I also just want to mention we're currently, and this is an example of governance, non-regulatory governance, we're putting together guidance, considerations for safe development of nanotechnology. Because our funds were cut and we lost 9 staff last year, we almost completely lost our sister agency, TURI, the Toxics Use Reduction Institute. Thank God they're back in the budget this year. This was not produced last year when it should have been, and in fact is still under review. So if anyone is interested, please give me your card. I'll send you a draft, and you can still comment on it. And also, I have copies of my comments, which will not include everything I say, but they're right over there if you're interested. I want to just give some of that big picture stuff. I think we're dealing with a 7-sided universe, or a 7-sided box, or a 7-sided prism through which you can see things. And that's the holistic viewpoint. I've listed what those different dimensions are. In the interest of time, I'm going to just let you look at them and not run through them. But what I want to say is that we think that the stakeholders, we begin with the stakeholders here being business and the regulatory agencies, but we have what I call incidental stakeholders, and that's everyone who's affected by the presence of nanomaterials in commerce in our society. And I call them incidental stakeholders, but they are of primary importance. And you see them when you look through the 7-sided prism. So we need to actually take that view, we need to construct that prism, think of this actively in terms of life cycle and everything that happens with the nanomaterials, and then we can see who is impacted, and we need to actively include them as stakeholders. I could have spent the whole time on this, and I can get lost in this, and that's another reason why I say we need to stay in focus with a big picture, because when we look at each one of these issues or these programs, there's a terrible thing going on here. Yeah. I would ignore this, except you need it, right? Yeah. Okay, we're going to get lost in this, and there's a lot of details here. I just want to state generally that since I put these slides together, I thought of several other things that need to be considered. There are people who point to the Endangered Species Act as something that needs to be thrown in here, and of course I left out the Safe Drinking Water Act, which is a problem. There is possibly corporate disclosure required under Securities and Exchange Commission, and then there's the whole world of tort liability. And you saw the phrase appropriate measures to control risk as a regulatory trigger under REACH. or standard under reach. Now, that's the essential idea of negligence. Are you applying appropriate measures to control risk? And someone can sue you if you breached your duty to do that. So we're just waiting for a good lawyer to make that case in court. And, of course, we have nuisance as well if nanomaterials remain and create a problem. We have general public health authority for state, local, and federal health agencies to take action when there's a threat. We have insurance law to consider, and we have business practices to consider that can drive behavior, exclusions or differential pricing. We have product liability law that we need to consider. Did you have appropriate warnings? Is there a manufacturing defect? Are you violating an implied or express warranty? And you also need to turn all of this around if you're in business and think of this on the other side. What protections do you get by proper warning? I mean, think of tobacco. We sell tobacco, a product that kills people. And you don't get sued because you've got a warning on it. Warnings are tremendously valuable to businesses. They shouldn't be thinking about all of these laws as things to avoid. These are things that they should be concerned with, actually, because they will help them to stay in business. We have purchasing policies. Environmental preferable purchasing is a hugely growing thing at all levels of governance, and they can easily include no nano here. And of course, corporate supply chain programs include purchasing policies, and this involves questions of notification, and then you're getting into contract law. You didn't notify us that this was a component in here. And then if we're in court, we're talking about joint and several liability, and we're talking about principles of strict liability. So there's a lot of law to master. Linda Bregan was kind enough to say she was looking forward to what I would say about what's at the state, and so I'm going to make this comment, which is that we have this incredible program, the Toxic Use Reduction Act in the state, which could be used to address nano. However, it has a threshold limit of 25,000 pounds or 10,000 pounds or maybe in some cases 1,000 pounds. And if we want to, we can call this a PBT, a persistent bioaccumulative toxin, and get to a lower one, but that's going to be a lot of work. So a huge effort is necessary to get over that volume threshold question. But we also have an employee threshold, and many laws have employee thresholds as well, so you can't go after the very small companies. And a lot of laws have effective small company thresholds. So similar to going after a small R&D development initiative, that might be hampered by an express R&D exemption, but it also might be a small entity. And even if there's not a specific small entity exemption, there might be an effective one because the agencies don't have the resources. And so historically, we see them focusing on the major risks and the major sources. In addition to that, we have other things that are barriers to agencies acting under these various authorities. And I also want to mention down at the bottom, you'll see CPSC, that's the Consumer Product Safety Commission, and FTC, the Federal Trade Commission, which the authorities there could be used to require proper notifications. And I also just want to mention we have also international trade rules that we could be looking at here. We have something called the Basel Convention, which could cover wastes, but I don't know what there is for covering imports. That's handy right now to look at. And of course, we have standards, which are both on the professional and the trade association level. I have only 2 minutes, and I have far too much more to talk about. I also just want to mention that before we can trigger these laws, we usually have to have good evidence of harm. We have long processes to go through, and we have barriers now that have been put in place in recent administrations. We have laws which require the agencies have good data and are avoiding junk science, that they avoid too much paperwork burden, so that means that they are limited in what they can request from companies. We have the CBI was mentioned, confidential business information, and then we have approvals that you have to show a good cost-benefit analysis before you can go forward. So let me very quickly race through what I want to say. Public necessary dialogue is necessary. That's how you actually get these ideas out there. And safe development avoids both the type 1 error of overreacting and over-regulating and the type 2 error of failing to regulate when you should have. And the idea here is to avoid both types of error and not make the mistake of a narrow approach, that's why I say big picture, that only does one of them. Right to know, RTK, is fundamental, and it's my opinion that that's where we should begin, that is not only for moral reasons but for practical reasons. It's the quickest way to get people to be safer and to get out there the information that we need. And right now we have a situation where thousands of products are out there already and people don't know what's in it. And that is causing hysteria. So we need to act quickly, and this is the quickest way to do this, and that should be of concern to proponents of the technology. Deferring responsibility does increase the risk. They catch up to you later. A reactive approach is more costly, and that should be the concern of proponents, not just those who are for safety. Just a couple of comments about right to know. It can be very complicated. Let's make it very simple. Use the rule of empathy. What should we say right to know rule should be? Put yourself in the place of the incidental stakeholder, and what would they want to know? This is a little more difficult when it's a microorganism, but I think we can use our imagination. The rule of safety: would transmitting the information reduce the risk? And that prevents you from having a right to know that is bulky and a burden and doesn't do anything good. We have had way too much bad discussion about the precautionary principle. So let's talk about the precautionary principle so everyone can agree. And I think you can see what I've got here. You don't just put up the barriers when you can actually see the cracks in the frozen lake. You stop skaters from going out there when it's getting hot and you know that they're going to fall through. And frankly, I think we're there. I also think that we can argue and discuss forever the various classifications, and I've seen so many versions of the definition of nanotechnology. And I just want to offer this very simple approach. I worry about them when they're free, instantly releasable. I worry about them less when they're embedded, but I want to know what conditions might cause them to be released. So let's focus there. And then everybody says to me, well, surely you're not talking about the tennis racket or the golf club that has it very much fixed in there. And I go, oh, I'm not worried about it until end of life. We need a multi-governmental approach. That has worked well when we have the ability for local or state to move forward, and we have the feds acting to make sure that there's a minimum. And it can be a disaster if the federal action preempts local or state action. So this is a very simple concept, but we forget this when we start talking about this on the federal level. This is now the major concern of those who are rather sophisticated about TSCA. We see the chemical companies saying, yes, we need TSCA reform. Well, of course, they would love a system that preempts state and local stricter rules. So we don't want that. And I don't know who I'm speaking for here, but I guess I'm speaking for everyone at the state level. But that's just my guess. And this has worked well with the clean air and clean water and hazardous waste laws. And I don't think, frankly, it has worked well with the laws where state action has been preempted. Thank you.
I want to invite our panelists back up to the front of the room. We have a few minutes for questions. I know our break is supposed to be at 11, but I'm going to have us go for 7 minutes until 5 after 11. And everybody's going to be sitting in front. Linda, are you still there?
I am.
Great. Okay. Yes, sir. Please remember to state your name. We need a microphone first.
Oh, okay.
Name and affiliation. Thanks.
Thank you, Macan Bang from the... Oh, sorry. Okay, it's good like this? Okay. Macan Bang from the Geneva University Law School. Thank you very much for your stimulating presentations. Just a quick remark with regard to the distinction between new and existing. It's interesting to see that it's a common debate when it comes to new technologies, because that was exactly the same, and it's still exactly the same debate in the field of genetically modified organisms, mainly those genetically modified organisms for food. Are they traditional food or novel food? So it's interesting to see that we have the same debate here with regard to nanotechnologies. I don't know if it's really the real debate. Like I tend to think that regulation should focus more on risks. The very fact that these substances are characterized with important risks, I think that should be the focus of the legislation, and not really to enter into a debate: is it new or is it existing or old thing. Just to move a little bit on the topic of our conference, the global regulation of nanotechnologies. I have a question here for the panelists in terms of how should we frame a global regulation of nanotechnologies in terms of domestic regulation. So I'm not sure that I have heard here a clear statement on whether we need a specific domestic regulations on nanotechnologies, or is it okay to live with that fragmented world of various rules coming from different fields? And so, do we need a specific domestic regulation on nanotechnologies, or is it better to have code of conducts or voluntary regulations instead of having state regulations? And if we consider that we need a domestic regulation, what should be the features of that domestic regulation for nanotechnologies? For instance, life cycle. I haven't heard a lot about that aspect.
Let's let the panelists address your mini.
But it's still related. But I'm finishing now. So, do we need to have life cycle aspect, risk management, risk communication provisions in that regulation? So that would be the end of my question.
Does anyone want to take a stab?
I would like to make a couple of comments. I don't it's on, but
It's on.
okay. I would like to comment that I think we need to begin with public dialogue, because if the state agency comes out or the federal agency just announces, I mean, they do that, but the best thing is to create a public consensus, because that will be the rule that incorporates the widest perspectives and is most practical. So again, I believe the public dialogue is necessary, and it would be premature for us to describe for you now what that regulation should encompass. I also want to mention, except in large terms, mention that the aforementioned Terry Davies of the Woodrow Wilson Institute has issued a wonderful report, Oversight of Nanotechnology, which talks about how it should be, and talks about uniting the environmental and consumer protection effort, and talks about this illustrates how we need to create a new system, because it just shows how fragmented and inefficient our system is, which is really an important point. We should be using the nanotechnology example as to teach us how to rebuild our environmental protection and consumer product protection system. But I am not sure we're going to be able to do that on a fast track. And I believe we should start with those non-regulatory guidances first and let regulations develop out of them. And I think if we have the effective public dialogue, it will be clear what more we need to do.
Other panelists?
Well, it seems to me that, well, what was pointed now is crucial to this thing. Public awareness of what's going on, and having a consensus to establish local, and it depends very much, how local you should go in the different regulations in different countries. But for sure, it's something that if it comes from a consensus, it's going to work better and it's going to be more effective.
Diana.
About 5 years ago, one of the debates in Australia was whether we needed an overarching nanotechnology piece of legislation. That debate has now moved on, and there is really no discussion of that because it was seen as impractical, ridiculous, and very costly for probably not a lot of gain. So the approach I believe that the Australian government are likely to take is really looking at agency by agency, legislation by legislation, and really looking at more tweaking the legislative approaches as opposed to overarching wholesale change. In Europe, you're already starting to see that, obviously, with the cosmetic regulation coming into play. There are nano-specific provisions already incorporated into that piece of legislation. That is the path that I see the Australian government most likely adopting. In many ways, a lot of governments seem to be taking a wait-and-see approach. Who's going to be the first mover? Who's going to set the standards? Whatever approach is adopted, there has to be some degree of consistency for multinational organisations operating in that space. To have so many conflicting definitions incorporated in legislation will be very challenging. But I think what we also have to remember is our regulatory frameworks aren't perfect in this to start off with. Nanotechnology is probably just highlighting some of the issues that have been there for years and years. So in terms of how we approach addressing the regulatory challenges, we have to look at how best do these regulatory frameworks have to be developed anyway to ensure that the environment and humans are protected, and look at nanotechnology as really just being catalyst for some of these discussions, not a wholesale problem that we need to change the regulatory frameworks to address only that problem.
Linda, I don't know if you could hear the question.
I had a little trouble hearing it, I'm sorry, and I couldn't hear Diana at all. So maybe if there's another question, if it's possible to repeat it, that would be tremendously helpful. I apologize.
No problem. We're also running out of time. So, Sonia, do you want to take another question? All right, let's have one more question, a short question from the audience. Yes, sir.
I'm Mark Sarno. I'm at Carleton University in Canada. Just a question for Dan Bowman about this issue of centralizing nanotechnology oversight. Australia is one of the few countries that has a gene technology regulator. I'm just curious if this has worked well for Australia and if there's something we could learn from that.
Technology regulator has been a well accepted, new regulatory agency. While we do have a specific regulator for that area, they actually do work very closely with the other regulatory agencies. So it is perhaps because of that close relationship that we've seen it done so well or being accepted. And obviously, because we have the gene technology regulator, that is why the issue of having a nanotechnology regulator came up very early in the discussions. We saw the gene technology regulator working well, so hey, why not do it with nanotech? But obviously, with gene technology, it's a lot easier in terms of pigeonholing what you're going to be regulating. And I think as soon as people started to work through what is nanotechnology, what are the areas, that they saw an agency-by-agency approach was going to be far more feasible. And also in terms of the expertise, having a nanotechnology regulator would require so many diverse skills within the people that you'd have in the agency that it was just not a viable option. So it was seen that it was better to capacity build within each of the regulatory agencies and then bring those regulatory agencies together on a regular basis, to workshop for foresight and other scoping activities. So I don't see us getting our nanotechnology regulated despite some of the earlier questions or proposals around it.
Okay, I'm guessing that we should wrap up. And I appreciate, Linda, thank you so much for staying on the line. And
thank you for including me.
I want to thank Sonia Rowland and her team for inviting all of our panel, the engaging and knowledgeable speakers, and especially Dave McNeil for the tech support on the EV for our first speaker. Enjoy your break, and we will be back here at 20 after or so, 20 after 11. Thank you.